Okay, we're live. This is Attorney Vincent Davis, and this is The Secret: How to Fight CPS and Win. And I'm joined by two very special guests. We have Miss Cassandra Woodard, who is a host on our different CPS shows on the different social media platforms. And how are you, Cassandra?
I'm good. How are you?
Doing good. And then, of course, we have the one and the inimitable one and only Miss G, Miss Georgette Truman. How are you, Miss G, today?
Just lovely, Mr. Davis. The
Good,
best day ever.
good, good. So I heard you had some good news today, Miss G.
Good news?
Yeah. Oh, maybe I heard, through the grapevine that you were had an appointment today and got really good news and no? Okay. You don't want to talk about it?
No.
Okay. Look what Deidre Payne says. So happy Mr. Davis is going to take over your case, Cassandra. Cassandra, did you email me anything today?
I text Georgette everything that she asked for.
Oh, okay. So Georgette is taking care of it for us.
Mm-hmm.
Okay. Very good.
Usual.
Very good. Anything either of you want to share before we get into the meat of this show? This is going to be a very meaty show. We're going to talk about law. We're going to talk about, strategy, stuff like that. Anything you guys want to mention?
Well, I'm actually ready to hear what you had to say about this show.
Oh, okay. What about you, Miss G?
Yes, I do want to mention something.
Yes.
This is not a political issue that I'm about to say, but I think you guys need to be aware. Democrats on Thursday anonymously voted to block legislation that would have required to inform parental consent before a school provides mental health services related to sexual orientation or gender identities of students. Every single Democrat in the House voted against that. They do not want to give any parental rights to parents is almost beyond belief. That the government would imagine that they have the authority over our children. If there was ever a time, we have to find our voices now. This is not a political issue, as I mentioned. This is an issue about what our lives will look like and what our children and grandchildren will become. This is a message to all of us about our children of this generation. We cannot be silent. Parents' authority over their children's cannot be opted out, cannot be given away to the government. I refuse to relinquish that to an elected official. So you guys need to be mindful. You need to vote. And I understand you guys, some of you are Democrats, some of you are Republicans. I am an independent voter. I vote for the right person. So please, I'm begging you to vote. And we need to get these mother F's out of office immediately. I'm definitely not voting Democrat at all this year. I would vote for a monkey before I vote for a Democrat. So you guys need to research. You guys need to know what's going on and vote wisely. That's all I need to say.
All right. Well, thank you for that political statement, Miss G. And I have to make sure that
This is not a political issue. I just said that. This is about our children.
I got to make sure that I vote to cancel out her vote this year. Okay. So yesterday, Miss G asked me to talk about and explain two code sections in California. Now, for all of you around the country, um, you know, these two sections or something like that exist in your state's laws. You just have to find them, talk to your attorney about them. Okay. The first one is Welfare and Institutions Code Section 361.3. And before I go any further, Cassandra last night gave us a resource that I didn't know about. I had heard about it, but I never used it. And was looking at it today, and I was amazed at how this thing is set up, this database is set up. Cassandra, why don't you tell us once again, because a lot of people watching, they're not all in California.
Hmm.
They're all over the country. So when I talk about a California law, they may be wanting to look up what the law says in their state. So what is that resource?
It's the Child Welfare Information Gateway. Um, I think it's childwelfare.gov. There's a statutes search for each state, and you could look up, like, you could search it through different categories. It has different categories that you could search up, and then it tells you the statutes for each of those things in every state.
So last night, when Cassandra told us about this, Miss G posted it. Oh, I see she's posted it again. There's the link. And I suggest that all of you that are out of state take a look at that, because when I talk about a California law, you can try to find the like law in your state. Okay. So what we're going to do is today we're going to talk about Welfare and Institutions Code Section 361.3. Was that the section, Ms. G?
Correct.
Okay. So the best way to talk about this statute is to read parts of it and dissect it as we go along. Okay. Because this particular statute is a little bit complicated, but it's extremely important. And in my opinion, it's probably the most important law as far as parents are concerned in the juvenile dependency / CPS court system. Okay. And that's saying a lot. That's saying a lot. And it is often overlooked and not used for the parents. Okay. So let's go through it. 361.3 is a statute that is used during the dispositional phase of the case. The dispositional phase is where the court has to decide whether the children should be returned to you or not returned to you prior to the 6-month review date. So it goes detention hearing, jurisdictional hearing, and then dispositional hearing. If you lose the dispositional hearing, your next court date, unless you file a 388, your next court date is not going to be for 6 months. So theoretically, it could be 6 months before you get your children back. That's why this statute exists and sets forth the framework. Now, the first thing I want to tell you is 361.3, and for tonight's purposes, I'll just call it point 3, is divided up into a number of subsections. So the law is called the section, the whole law, but the law is divided up into an A section, a B, a C, a D, an E, and an F section. So 6 subsections are involved in 361.3. So that will give you the overall framework. Now remember that each subsection talks about something a little bit different that's supposed to happen at the dispositional phase of the case. And as I say, and as I have said before, it's hard for a parent to lose the dispositional hearing. If you actually have a trial, it would be hard for you to lose that dispositional hearing because the law is so on your side. Now, a lot of times what I see is parents don't have a trial at the dispositional hearing. They just, agree with the social worker and choose not to put forth any evidence, or they have a trial and they show up and the parent and their attorney has no evidence to prove. Remember, if the only thing your attorney is going to do is argue, 99.9% of the time, you're going to lose. Period. End of story. And the reason is because an attorney's argument is not evidence. Okay? It's not evidence. And the judge has to make a decision based upon the evidence presented to him or her. All right. So subsection A of 361.3 says, in any case in which a child is removed from the physical custody of his or her parents pursuant to 361, preferential consideration shall be given to a request by a relative of the child for placement of the child with the relative, regardless of the relative's immigration status, period. Now, I've been doing this over 30 years. And that last phrase is very important, regardless of the relative's immigration status. In the old days, and not even the old days, somebody tried to use this argument against my client's relatives. If the person that you want to give the children to is here illegally, that doesn't mean anything. The social worker can't use that to keep the child away from those relatives. Do they do that? Yes, they do. Do they do it unspokenly? Yes, they do. Now, what happens at a disposition hearing? You rarely see the issue of placement come up. All right. And I get the feeling sometimes a lot of judges, not all, don't even want to deal with this issue. But it's part of the dispositional case and the dispositional statute. The placement of your child, whether in foster care with strangers or with friendly relatives who may know the kid, is extremely important not only to you, but to the child. And here we have the law saying that preferential consideration shall be given to a request by a relative. So at the dispositional hearing, if at all possible, either online or in person, ask the relative to come to testify so that the judge can meet that person on the witness stand and tell the judge that they want the child placed with them. Having a child placed with a relative, okay, is akin to you being charged with a crime and being out on bail. Would you rather be out on bail fighting the state in your criminal case, or would you rather be in custody? If your child's in foster care, I liken that to your child, or you being in custody on a criminal charge. So that's how important Section 361.3a, just the first sentence, is. So always make sure that you and your attorney, if it's within that person's strategy, argue and present evidence on placement with a relative. Now, what I get a lot of times is the county or the judicial officer doing the disposition hearing and saying, we'll put the issue of relative placement, later. And when you get the report from the department or CPS says, we don't want to place with the relative. Sometimes the judicial officer doesn't give you the right to have a trial on that issue. And a trial on the issue means you get to cross-examine the social worker and you present evidence on why placing with grandma or grandpa or Uncle Bob or Aunt Mary, or the adult sibling, is better than the strange foster parent. All right. So up to this point, Cassandra, do you have any questions for me? Okay, so Cassandra's on mute, and I'm wondering, I'm not really good at
I
reading lips.
understand, and I don't have any questions.
Okay, let me unmute Miss G. I can't unmute Miss G. She must have muted herself.
Yes, Mr. Davis.
Do you have any questions so far?
No, thank you.
Okay. The second the second sentence of subdivision A of 361.3 says, in determining whether the placement with a relative is appropriate, the county social worker and court shall consider, but shall not be limited to consideration of all the following factors. And then it lists 7 factors. Okay? The factor number one is the best interest of the child, including special physical, psychological, educational, medical, or emotional needs. Number two, the wishes of the parent, the relative, and the child, if appropriate. Number three, the provisions of Part 6, commencing with Section 7950 of Division 12 of the Family Code regarding relative placement. Number four, placement of siblings and half siblings in the same home, unless that placement is found to be contrary to the safety and well being of any of the siblings as provided in Section 16,002. The good moral character of the relative and any other adult living in the home, including whether any individual residing in the home has a prior history of violent criminal acts or has been responsible for acts of child abuse or neglect. The nature and duration of the relationship between the child and the relative's desire to care for and to provide legal permanency the child if unification is unsuccessful. Number seven, the ability of the relative to do the following things: A, provide a safe, secure, and stable environment for the child. B, exercise proper and effective care and control of the child. C, provide a home and necessities of life for the child. D, protect the child from his or her parents. E, facilitate court ordered reunification efforts with the parents. F, facilitate visitation with the child's other relatives. G, facilitate implementation of all elements of the case plan, referring to the case plan of the child. And H is divided into two sections: to provide legal permanence for the child if reunification fails. But H2 says, however, any finding made with respect to the factor considered pursuant to this subparagraph and paragraph sub G shall not be the sole basis for precluding preferential placement with a relative. Then it goes on to I, that they arrange for appropriate and child safe child care as necessary. Now, it goes on and it talks about a few other things, the safety of the relative's home, that type of thing. And here is an important part. The legislature declares that a physical disability such as blindness or deafness is no bar to the raising of children. And county social workers' determination as to the ability of a disabled relative to exercise care and control should center on the relative's disability if it prevents him or her from exercising care and control. I took a call about a week ago where a relative told me that they were denied placement because they were blind. But here is the law that actually says, and it's in section 8, subsection or subsection 8b. You can't use that. All right. So that is the essence of section A of 361.3. Miss G, do you have any questions so far on what we've covered?
The part that you just mentioned, that if you're blind, that doesn't, it's basically illegal for them to say that. I
Well,
have a parent.
it doesn't say that.
Oh, did I
What
miss it?
it says is basically you can't use that unless it's going to cause a problem with the safety of the child. So if a social worker says, no, you can't have the child because you're blind, they better have reasons to support how that ties to child safety. And the law says being blind does not automatically disqualify you. We can't just assume that because you're blind, you can't take care of the kid. I once saw a case where the social workers were being sued because they wouldn't place the child with a grandmother because they said she was too old. Now, she was old, but they couldn't prove that she couldn't take care of the child even though she was 80 years old. Okay? Yes, Miss Cassandra.
Actually, I know that they that's one of the things they couldn't, or they couldn't prove that the father of my kids, he was actually partially blind at the time that he was trying to get the kids back, and they couldn't, they were trying to use that kind of, but then they couldn't prove that he couldn't take care of the kids because he was taking care of the kids at the time that he became blind and
Right.
like partially blind. So
I've seen a lawyer, a very good lawyer, use the Federal Americans with Disabilities Act and sue these people when they use a handicap without having any other backup. You're blind, therefore you can't have the kids. Okay, and that lawyer was successful. So social workers, but and they rarely do, in my experience, come up with facts to prove, oh, you're blind, you can't take care of the kids. Miss G, did you have something else to ask or add?
Um,
Okay,
no.
okay. So we're talking about WIC 361.3. The next subdivision of this is subdivision B. And it states, in any case in which more than one relative requests preferential consideration pursuant to this section, each relative shall be considered under the factors enumerated in subdivision A. So all those things that we were talking about. Consistent with the legislative intent for children to be placed immediately with a relative, this section does not limit the county social worker's ability to place a child in the home of a relative or non-relative extended family member, pending the consideration of other relatives who have requested preferential consideration. Okay? So, third cousin, once removed, can get the kid before grandma, at least temporarily. All right? But when you have the disposition hearing and you want the kid to go to grandma, instead of that cousin, that third cousin you don't even know, you got to have a trial about it. And you got to prove to the judge that grandma should have the kid. Now, here's something important because in subsection C, it says for purposes of this section, meaning 361.3, number one, C1 says, quote, preferential consideration, unquote, means that the relative seeking placement shall be the first placement to be considered and investigated. Number two, quote unquote, relative means an adult who is related to the child by blood, adoption, or affinity within the within the fifth degree of kinship, including step parents, step siblings, and all relatives whose status is preceded by the word great, great great, or grand, or the spouse of any of these people if the marriage was terminated by death or dissolution. Now that's a whole lot of people. All right. Your people you talk to, the people watching this show, have those people in their family or connected to their family. And by the way, I'm here to tell you that those people can live anywhere in the world. They don't have to live in your county. They don't have to live in your state. They don't even have to live in the United States. All right. So there's no reason in my mind that a child should not be with relatives. Section D of 361.3 states, subsequent to the hearing conducted pursuant to 358, whenever a new placement of the child must be made, consideration for placement shall again be given as described in this section to relatives who have not found to be unsuitable and who will fulfill the child's reunification or permanent placement requirements. In addition to the factors described above in subdivision A, the county social worker shall consider whether the relative has established and maintained a relationship with the child. Now, do you ever get people that talk to you and say, hey, I'm, the uncle or the great uncle or the great grandfather, and I called the social worker, and the social worker won't let me visit? From a pure conspiracy point of view, this may be the reason why. Because a lot of times when a child has to be moved from one relative to another or from one foster home to another, they write in their report, well, the relative who wants the kid has no relationship with the child. Well, they don't have a relationship with the child because you wouldn't let them visit. Now, here's the interesting part. There's a similar law talking about something else. The court can also consider the relationship of the child before the case started. Now, how many times has a relative said to you, hey, I used to see the kid all the time. Case started, social worker won't let me see the kid. But the kid knows me or knows that relative. So in my opinion, that should be taken into consideration. And we'll talk about this at another time, that relative should be filing a 388 to get the child placed with them or to have visits with the child. Okay? Now, there's subdivision E of 361.3 says, if the court does not place the child with the relative who has been considered for placement pursuant to this section, the court shall state for the record the reason placement with the relative was denied. The reason. Now, I'm not sure. Well, that's not true. I haven't seen that in a majority of the cases that I've dealt with. Usually, you want kid placed with grandma, and then grandma, the social worker says no, and then you have a hearing, or you try to have a hearing regarding placement with grandma, and the court says no. And sometimes that's it. Sometimes they say, well, it's not in the best interest. And to me, when a court is able to say that, that means that you and your attorney haven't done enough, presented enough evidence to show that placement with grandma would be in the child's best interest. So it gets back to strategy, implementation of the strategy, and your evidence. Hey, Miss G, I've been thinking, and I think I talked about this before, but, I've just been talking and haven't done anything about this. What do you think about some kind of show or seminar or something where I go through evidence for parents and I try to explain it? Now, I'm not going to be able to do it all in one show. It may take 10, 12 shows to do it. But what do you think about that?
A seminar, yes, and I think I did discuss that with you, but we did not go into depth. A seminar, I think that's a great idea.
Okay. Because I keep talking about evidence, and I don't think it really means anything to anyone because they don't know what evidence is. They don't know the rules of evidence. So it's me like talking, bullshit.
Mm-hmm.
I'm saying something, but I know what it means, but you don't know what it means. And nobody's ever explained it to you.
Right. And I think it should be like again, the seminar should be for people with obviously CPS cases, but individually, because each case is different. Okay. And oftentimes people think their case is the same as it's not the same. There's so much that plays in your case that you would not even begin to understand everything. And in order for the attorney to help you, you have to be willing to listen for that attorney's help and attorney's advice, because you will never, ever measure up to the knowledge Attorney Davis has. I mean, even I can't measure up. But, all that.
Wait. Hold on.
I didn't say that.
Grace.
Nope. I didn't say that.
Put that in a special video for me. We
Nope.
want to put that all over social media.
I know, right? That part. No, but no. On a much serious note, you guys, you
I
need.
was serious. What are you talking about?
Mm, you know what, Davis? So I want to meet you. That's what I want to do. I can't. But no, seriously, Davis has so much knowledge that I mean, and I'm not saying that because he's my boss, but his brain is wired differently, completely differently than the normal basic attorneys I've ever met in my life. So he is a great attorney, and you guys just have to listen carefully because I see a lot of your comments when he speaks, and he already addressed that issue, but you guys still questioned what he said. Some of you, not all of you, but just listen very carefully, and hopefully
You,
you'll understand.
I find myself saying this more to people,
Hmm.
and it's working in some cases and it's not working in others. A lot of people call me and they have a perceived notion of how the case works or how at least it should work, and that's wired into their brain. It's physically wired in their brain. The problem is that at least 50% of what they think is incorrect. So if you're making a decision tree and half of what you say is or believe is incorrect, you're going to make the wrong decisions in your case. I was talking to somebody today and I was explaining what the law was or is, and they were fit to be tied. We started talking about, you know, ethics and morality and what the law should be, and I don't mind talking about that once in a while. But listen, you called me to figure out how to win your case, not what's morally right and wrong. It's not the same. And I'm sorry to say that. All right, we're still on 361.3. The last subparagraph or paragraph in 361.3 is subdivision F. And subdivision F1 says, with respect to a child who satisfies the criteria set forth in paragraph 2, which is below, the department and any licensed adoption agency may search for a relative and furnish identifying information relating to the child to that relative if it is believed the child's welfare will be promoted thereby. Generally, everything in juvenile dependency court and CPS court is confidential. But here is a carved out exception that if the relative is being sought out and maybe perhaps is going to keep the child on a permanent basis, the law, at least in California, is saying, social worker, you can talk about the case with that relative, right? And if you think about it, in most circumstances, that makes sense. Not in all, but makes kind of sense from the child's perspective. And remember, when you're reading these laws, a lot of people read them as if it only applies to them as the parent. That's not true. I'm just the messenger, but a lot of these laws are looked at, especially by judges, from the perspective of the child. What the child attorney is saying is best for the child, not what's best for mom or dad.
Right.
You know, should it be that way? I don't know. That's one of those moral things that we could talk about for days. Like which religion in the world is the right religion? I don't know, right? Everybody has their own thoughts and beliefs. And that's the good thing about this country. And sometimes it's the bad thing about this country, right? Because we're all on different pages. Miss G, I saw your hand. Go ahead.
I just wanted to add that keep in mind, you guys, that social workers want to place children in a non-family member home. That's what they focus on the most. There's a reason for that. When Bill Clinton 1997 Act offered cash bonuses to the workers for the children to be placed in a non-family member home. Non-family member home. So they get bonuses higher when the children are placed in a foster home. So oftentimes the social worker would ask the parents or the siblings or the aunts and the uncles, the relatives that is, to become foster parents. So they can have control over them. So, and that also they can get more funding for that. So you guys have to be mindful as well. When they do not choose family placement and they make excuses, there's a reason behind every demonic action. Example, if your mother lives in Arizona, in the case in LA County, they don't want to transfer the case to Arizona because they're going to lose the funding. Why would they lose the funding? So they're going to come up with every excuse in the book as to why the child should not be sent to the grandmother in Arizona. So um, just remember, instead of them being 40 steps ahead of you, you should be 100 steps ahead of them and understand and research. And I think Cassandra and I mentioned that before to you guys. Do your research, do your homework. Do not just sit around thinking that somebody is going to come and help you and save you. No one is going to help you. I've talked to a Christian lady today. God bless her soul. I told her I'm Christian too, ma'am, but I'm not going to sit around and ask God to help me when I'm not doing anything to help my God either. I mean, God wants us to take the initiative, and he sends us people to guide us and give us wisdom and understand what's going on around us. And I mentioned that story the other night with Attorney Davis when this person is drowning in the ocean, and God sent them so many people to help them, and they said, "No, we're waiting for God. We're waiting for God." But then they die, and then they meet God and say, "God, why didn't you help me?" He said, "I sent you so many people, but you refused to accept their help." So Christianity has nothing to do with it. And I am a Christian woman myself, and I love my Lord with all my heart. However, you guys need to stop thinking that way. That's all I got to say.
Anything to add to that, Miss Cassandra? Okay, I can't unmute you, Miss Cassandra, because you muted yourself.
No, I'm unmuted now.
Okay.
No, I don't. I just like Miss G said, we've told people to do research, and I did a lot of research, and that's how I found the website that I told everybody about yesterday and today. And like, do your research, and it really does help. It's like you can't just rely on your faith. You really can't. You got to rely on you.
Well, your faith is important too, but God didn't tell us just to sit around and say, "God, help me." He
Yeah.
didn't tell you to walk in that fire or throw yourself in a pit of hell and say, "God, help me." He's going to say, "Why did you go there to begin with?" You know, we can't put our God to the test. So when you call yourself Christian, you need to know how God operates as well. So read your Bible, not just call yourself Christians.
Okay, I just put up a post on one of the Facebook sites by Rosalinda Castro. We started a group here in Northern California.
Mm-hmm.
Northern California Families United, Yolo County, Sacramento, and surrounding, I guess, areas. That's great. That's great. As a matter of fact, Rosalinda, if you want us to have a special stream or meeting with you guys, let us know. Let Grace know. Grace at Vincent W. Davis. She's the producer, and she can set something up for you. Okay? Because I love to see people organize. I love to see them try to make a difference.
Mm-hmm.
All right? All right. Miss G, I wanted to go over section 388
Mm-hmm.
tonight, but I don't have enough time to do that. 388 is a long section in the Welfare and Institutions Code, and it's a lot more complex than people believe or people think that it is. A lot of people say, well, I'll do my own 388. I'll just get the form, fill it out, and turn it in. That's not going to work. I mean, well, I shouldn't say that. That's a bad strategy.
Mm-hmm.
It might work 1 out of 1,000 times, but you got to understand what you're doing, how to do it. And then heaven forbid you get your 388 granted, and you then have to put on a trial. See, 388 is a two-step process. You got to file the 388, then it has to be granted. When it's granted, that means you only get a hearing.
Mhm.
You could go to the hearing and you could still lose the hearing, right? So it's, that 2 or 3 step process you got to be thinking about. It's just not printing the form out on the internet and filling it out and filing it. And a lot of times, you're only going to get one shot at your 388. Not all the time, you might get multiple, but generally, treat it like it's a one-shot deal. You got to do your best, put your best foot forward.
Right, because it's a request to change the current placement of the child. So it's very important to do it right.
Yeah. Deirdre says, I just feel like there are enough children out there that need a home to go to. So why do they have to steal mine?
Because damaged goods are not adoptable, healthy children are. So they social workers are, you have to understand, they're demonic entities. They're not normal. And I don't care what anybody that disagrees with me, that's on them. But they are a demonic entity. Their strategy is demonic, in a demonic way. Um, they cannot, or they will not be able to adopt children like that who are damaged. That's why there's a lot of children who are hurting in their own home and they're being abused and they keep them there. No one helps them. But they go after the children who are in a good home, good parents that love them, and the kids are attached to their parents and love them and want to be with them. Children in general, when you remove a child from a loving mom or a father, you're literally breaking that child into pieces. And those pieces will never mend again. They will never, I don't care what you try to do, it will never be the same again. So oftentimes you guys hear about stories about children being abused, and the social workers are called and they're not doing anything. They don't want to do anything. They don't. What's that is that you guys do not understand that there's two different foster parents' homes. So there's an adoptive foster parent home and and a foster parent home that doesn't want to adopt. So oftentimes the children are put in an adoptive foster parent home. I told you guys before, they get more money with adoption. They're going to always aim for adoption. That's why social workers withhold evidence. They keep the truth from the court. And they know the judges are going to take the recommendation. And that's why they want you to stay with the court appointed attorney. I had a client that hired us today. As God is my witness, they called me, and I know she's watching the show, her and her husband. They called me, and she said to me, or he said to me rather, he asked the court appointed attorney for the meeting, the court hearing tomorrow, because it's online. He wanted the phone number and the access code, for Attorney Davis to be in the hearing. She got so mad at him. She said, well, since you hired another attorney, I'm not going to give it to you. And she refused. And I sent an email to our back office. I explained the situation and what she said to them. She refused to give them the information in LA County, court appointed attorney, because she's upset. Why is she upset? Because she wanted them to lose. These court appointed attorneys do not want to help the parents. If they did want to help the parents, they wouldn't lie to the parents and say, admit to the allegations to get your kids back, and it's all a lie, and they never get their kids back. Oftentimes parents, out of desperation, they admit to it because they know, the court appointed attorney, that if they admit to it, A, they're not going to get their kids back, and B, they can't sue them because you admitted to the allegations. So you guys have to be mindful. You guys have to understand the trickery of the devil himself and the demons that follow him. They are going to get what they want. They're not there to reunify you with your kids. They're not there to reunify children with families. It's all a freaking facade name. Just facade. just to distract you. You got to do these classes. Then you do your classes. You still don't get your kids back. Do drug testing. You give them 35 clean drug testing. You still don't get your freaking kids back. So what is it? Reunification to get what? So everything they do, don't just take the word and say, oh, okay, well, the social worker is going to help me. She said she will. And then all of a sudden you have a new social worker, bitch from hell, that doesn't care about what the previous social worker told you. See, you guys do not understand the trickery of the system. I get angry because I'm very passionate about parents' rights and children. Children will never be the same when you strip them out of a good home. I mean, Cassandra, example, great mom. Great mom. She's not even the offending parent. Her daughters are never the same. Never the same. They rather have her daughter run away on the street than for them to be with their mom. The social worker would not look for a teenager running away who ran away. They will tell the foster parent, let it go. Let them come back when they feel like it. That is crazy. Crazy. So please do not just take the word of a social worker and think it's gold. It's not gold. It's not. And Cassandra, correct me if I'm wrong.
You're right. That's exactly what happened. They did stuff like that to me.
Yep.
All right, folks. For tomorrow night, we're going to hopefully we'll have a guest, and we're going to talk about Section 388. And for those of you that are outside the state, you'll use that resource that Cassandra talked about and what Georgette, Miss G, posted, the link to find your 388 in your state. All right. So I want to thank everybody for watching and listening, and we'll see everyone tomorrow at 7 p.m. Good night, all.